Yes.
Are they my lords back? Ah, they're here. I was just going to say, my learned friends instructing solicitors to be stuck in the queue to come in, but if we can push on without them.
Yes. Are you all right? Everybody's all right to start? I think we should. Thank you.
So, my lady, back to particulars of claim. I was showing the nature of the dispute, and also I'll come back to my Lord Zacaroli's question about, Lord Justice Zacaroli's question about the state of the pleading. We just looked at paragraph 14, which was this tab 6 in the full bundle, page 73.
Yes.
And we had got, I'd drawn the court's attention to the back end of that paragraph. Secondly, in the event of Mr. Cushing's death, the prospect of completing the TVM using visual effects so as to be the first to effectively resurrect Mr. Cushing was a valuable commercial asset expected to attract significant public interest. We then look at what the defendants, what the appellants did and how that has been pleaded and what the state of the evidence before the court is on that. Things are not entirely certain. So at paragraph 16, we set out our understanding in relation to the development of the film. And then at 17, we say being a prequel to the original Star Wars film, the fourth and or fifth defendant required to include Mr. Cushing's character, the Grand Moff Tarkin, in the film without recasting. And then we say we've learned that acting and other physical doubles...
Do we need these paragraphs for the construction point?
We do to this. Well,
right.
It's not so much the construction point as the benefit and what's being taken. So paragraph 18, we say computer-generated imagery and or other special effects, the visual effects, were then employed to reproduce Mr. Cushing by superimposing or transferring Mr. Cushing's likeness onto the footage of the doubles. Now, as we'll see in the defence, there's a dispute as to what actually went on. So we say this is the taking of the benefit, as we say in 19 and 20, but the precise nature of what was done remains uncertain, and so the nature of which rights were utilised and what exactly has gone on in Rogue One in creating this. We know that there is a dispute as to it, in the paragraph 18 is denied as an accurate representation. It's accepted the visual effects were used, but we don't know exactly what's going on, which in my submission, when we come to consider the two elements, when considering transfer of benefit, so a benefit from my clients, we say to the appellants, the question of what they've actually done is a matter that may be of some contextual relevance and importance. So 18, we set out that computer-generated imagery was used. And then at 19, there's the reference to post-production of the film and that it included the Grand Moff Tarkin that was reproduced by 17 and 18, the method set out in paragraph 17 and 18. And then at 20, and this engages to a degree with the point Lord Justice Zacaroli raised with me, is our pleading of how a benefit was taken from us, the transfer, so the claimant being deprived of the benefits of its rights. The film was and continues to be commercially exploited by the fourth and or fifth defendants to their benefit, grossing over $1 billion worldwide. As a result, so as the result of their acts and what they're doing, the claimant was deprived of the benefits of its rights under the letter agreement, as outlined under paragraph 14. So we say, although we haven't pleaded out the construction, as I've expanded upon it today and discussed it with Lord Justice Burse, what we have pleaded is that the benefit, which in 14 is identified as being the first to effectively resurrect Mr. Cushing on screen as a valuable commercial asset, so that's our right to do that, is something we say that we were deprived of by this. And so within that, we say what follows from that is we have pleaded out our case that we are not able, we previously had the right to be the first to resurrect Mr. Cushing, and now we don't because someone else has had that right. We say we still have a right to make the TV film, but it's not the first, so that primacy has gone. But what we have not done, and this is a fair point, is we haven't set out in terms at this early stage in these proceedings our construction of the first part of H that while being the correct
Well, you haven't
construction.
actually pleaded you had a right to be the first resurrector, have you? You described that as a benefit. Being able to resurrect first was a benefit, but could be taken as a commercial description of what was going on in 1993. In fact, no one else was. So you would have been the first had you made the film. But I don't see anywhere a pleading or a recognition that there's a right to do that conferred by the agreements.
Well, my lord, in our submission, certainly my submission, that's what at paragraph 14 are pleading that in the event of Mr. Cushing's death, the prospect of completing the TVM using visual effects so as to be the first to effectively resurrect Mr. Cushing on screen was a valuable commercial asset. So that's something that we say that's our right to do so. I mean, we say we were granted under 10 when we set out the terms. There's the 10. Paragraph 10E, little Roman 6. This is our right to utilise extracts from other films or other programmes in which Mr. Cushing has previously appeared. So these are the points that we've pleaded out. So, my lord, it may be, and I take on board your lordship's criticism, but we say this is certainly a point that is open to us on the pleading and has always been, we say, the heart of our case. And it is perhaps, unfortunately, if it's flushed out for the first time now, and we learned from a learned friend that he takes a different view of what's going on, that shows, perhaps highlights the perils of going all the way to here on a strikeout application when we should have just got on and a Part 18 request could have been served.
It's a matter of construction, just so we have formally for the record, what meaning do the words in H have?
So H, the first word, let me pull up H, which is behind. That's at page 30.
Yep, we've got it, it's 37. Yes.
So, it's rather than if as a result of the illness. That is read to include it's if it's while or if as a result of the illness the TVM rather than is not produced, or it's while it's not produced, or until it's not.
Well, which?
Until it is produced. Well, while will do for purposes.
Right,
While
as a result of illness, demise, or any other
no,
reason.
sorry, yes, yes, for the period. While as a result of the illness, Mr. Cushing's demise, or any other reason without limitation whatever or howsoever, the TVM is not produced. So we say if, should we? So it's not a once and forever. It's a right that is ours until we make our own TV movie.
Given the or any other reason without limitation whatsoever or howsoever, why is that clause relevant at all? Why is the bit in commas relevant at all, if you're right, or at all? While the TVM is not produced, you warrant an undertake.
Yes. I mean,
what's all that doing?
Well, it's in the. I mean, it might strictly be said to be surplusage, but in the context of the letter, which is
well, that's very important, isn't it? So the letter is critical. Sorry, the context of the main agreement.
Yes, and indeed the letter is clear that these were additional terms that were brought in that in the light of Mr. Cushing's, the awareness of Mr. Cushing's terminal illness. So it's, my lady, in the context of what was going on at the time, and this is at the risk of giving evidence, this is that you have, the evidence has previously been put in court that Mr. Francis, from my client, was a personal friend of Mr. Cushing. Mr. Cushing wished to continue working, and this was a way, by allowing the film to be made, notwithstanding concerns of insurance and so on and so forth, that he could continue working up until his death. And that's something that Tyburn was recognised in this right to resurrect, if necessary, to make the movie. So at the time when the agreement was entered into, it was known that Mr. Cushing was.
I understand that. Okay, all right.
So, my lady, it may be that between paragraphs, as soon as you have any other reason or limitation whatsoever or howsoever, you might say, what's the point of, as a result of the illness, Mr. Cushing's demise? But it's not uncommon in contracts to have, this is the primary purpose, the primary result that they're contemplating, and then someone has added any other reason without limitation whatsoever or howsoever.
Well, they rather point to the word if, meaning if, don't they? Because what does while, as a result of the illness, the film while it's still not made, what do those words add? I mean, they seem to me to point to, as I say, if, meaning if.
My lord, no, those are the reasons. But it's I don't, exchanging if as a once for all rather than for and while, until, I mean, it's actually almost a derogation from our right. We say that we only have this right until we make the movie. Until. So while, as a result of the illness, or for a period as a result of the illness,
Yeah.
Mr. Cushing's demise. So
Right, okay.
it's certainly the pleaded, certainly the case that my clients have advanced, and believe they were advancing on the pleading, was that they even now have the right, subject to obtaining other permissions from any copyright holder that might be necessary, to make the TV movie, and they no longer have the opportunity to do so the first, because that right of primacy, which was brought in as a result of the blocking rights under age, has now been taken from them. Now, the right that was granted to the appellants is behind tab 5, clause 2 of the Memorandum of Agreement, and all we take from this is to point out that, so this is tab 5, Supplementary Agreement, page 44. This is broader. In fact, although it entitles, Lucasfilm entitles the appellant to reproduce the likeness of Cushing in and in connection with production of the picture, it also goes further. So it's not just production, exhibition, exploitation, advertising, promotion. It covers merchandising and is, if we see the tail end of the clause, the consent herein includes the consent to use or excerpts or stills from the picture which may contain the likeness in any publication, recording, or an existing and future theme parks, resorts, attractions, so-called location-based or other regional entertainment centres, cruise ships, any of the foregoing licensed or operated. We say it's not our case that what was granted was absolutely coterminous with what our client had, but it certainly encompasses the rights that our client had. So there were things that were granted to the appellants which go beyond our blocking right, insofar as that aspect of our right, but it certainly included our blocking right. Or sorry, the things that we were entitled to block. So my client has no contractual relationship with the appellant, but we say that a benefit that was solely my client's, which was the right of primacy in terms of resurrecting Mr. Cushing, or alternatively, the value of them being able to control that, the use of Mr. Cushing's image to resurrect him, was taken and has been used by the appellant with the permission of the estate. And so the primacy aspect of my client's right and its right to withhold permission from in respect to the Appellants Act is no longer available to it. No longer available to my clients because it's been in respect of the appellant's use. So that we say, is a benefit to the appellant, and there would have been, both in terms of the permission to be able to do so, and indeed in terms of the avoiding the cost that there would have been to the appellant to obtain our permission for a release if they had asked for one. And how that's then pleaded, we see at page 80, paragraph 38, we say, in the premises and particularly by reason of the matters pleaded above at paragraphs 16 to 20, so those are the things we just looked at, and 24 to 29 is those are more, that's it, the creation of the 2016 agreement between the First, Second and Fourth Defendants. The Fourth and Fifth Defendants have been unjustly enriched at the claimant's expense. So that's where we say we plead the at the expense of point. And then 39, you've seen that all ready, and 39B in particular. Further alternative, the Fourth and Fifth Defendants were enriched by the matters pleaded above, 39A1 and 2, without seeking, obtaining and paying for the claimant's permission if given to reproduce the likeness of Mr. Cushing. And C, the benefits and enrichments pleaded in the preceding subparagraphs through the claimant's direct expense and all were obtained as part of a coordinated or closely related transactions between the claimant, the First Defendant, the Second Defendant, as sole executors of the principal beneficiaries of the estate, and the Fourth and Fifth Defendants. So, by its defence, the appellant denied that any benefit had been received at all from the estate, but for the purposes of this appeal, they've accepted that a benefit has been obtained. But what's not defined is, and not explained, is the nature of that benefit. So while we're trying to decide the issue of whether there has been a transfer of what we claim is a benefit from my clients to the appellants, there is no set formulation that the appellants have advanced or concession as to the nature of the benefit they say they have received. And I say, in my submission, that's an important point because in particular, we say there's no explanation in the evidence or on any pleading of how Peter Cushing was resurrected in Rogue One, or what rights the appellants exploited in order to do so. And I can show you that the pleading is at 15 and 16 of the defence. So this is behind tab 7 on page 88. 14, they admit paragraph 16 of our pleading, and that paragraph 17, which is where we, and 18 were where we address the technical reproduction, the matters that we've pleaded. 17, they say, paragraph 15, they say, of paragraph 17, it's admitted, except that it is denied that there was any necessity for the film to feature the character of the Grand Moff Tarkin, whether by using the likeness of Mr. Cushing, or, as was also possible, having that character played by someone else. So they say it wasn't necessary for them to do it, and it was a choice. And then at 16, as for paragraph 18, it's admitted that the likeness of Mr. Cushing was reproduced in the film by means of visual effects, but the paragraph is otherwise denied. The precise details of how Mr. Cushing's likeness was reproduced are complex and not accurately summarised in paragraph 18. And then paragraph 19 is admitted. And then 18, addressing our paragraph 20.
And what are we getting out of all of this?
So what we're getting out of this is that when considering what benefit has been obtained by the appellants, and for the purposes of considering whether that benefit is, as we say, the same as the benefit it cut across the rights that my clients had, it is an important point in my submission that the nature of the benefit should be known, the benefit both that the appellants have obtained, so what rights were exploited, the manner in which they did it, and indeed the nature, to consider whether those rights are indeed something that cut across my client's rights of primacy. So and the nature, how close they are, what actually went on is something that in my submission might well be of relevance when it comes to deciding whether what we characterize as the transfer of a benefit from my client to the appellant is something that falls within the scope of unjust enrichment. So that's something that we say is useful, would be useful context for the trial judge, and it's something that's not available to you here. And in making any assumptions, even if you assume to the greatest degree available that we can't actually assume to the greatest degree available that they're utilizing our right, because there is a dispute as to whether or not our right that has been taken includes an ongoing right to make the TV movie. That's a dispute between the parties that has not been resolved before you and won't be resolved until trial.
Well, aside from that point, why does it matter which particular subparagraph under E was exploited or was used in the
No, my lord, it's not which subparagraph under E, it's which of the range of different possible rights. We don't know whether what the appellant did cut across the performer's rights of Mr. Cushing or not. We don't know whether they reproduced film footage in some way.
whether it's within the particular subparagraph.
That would be within E, but we also don't know about whether it's image rights. And
Why does that matter? Why does that matter?
My lady, it matters because if it's to be said that unjust enrichment does not apply in relation to, or can't be, we can't avail of ourselves of unjust enrichment if it's excluded in some way by a statutory licensing scheme in relation to performers' rights. For example, if that argument were advanced, then if there are image rights which are not so excluded, it would be relevant whether
I thought we were looking at two fundamental points. Was there a transfer of value? And then is it direct or indirect?
My lady, yes, we are, but in order to work out whether there has been a transfer of value, in my submission, we need to know whether the thing that was transferred is...
The thing that's transferred is on the face of the agreement.
Yes, but on certain analyses that my learned friend has advanced, there are things that he says are not within, or that I might say are not within the scope of unjust enrichment. So the nature of what was transferred, the precise nature of the benefit is going to be relevant. My lady, and it's... As we'll... when we come to look at ITC and Lord Reed's decision there, the thing that comes through again and again in my submission is that the particular circumstance, the particular facts of cases are important. And we say that's why it is dangerous to attempt to decide against my client and strike out its case when there has not been a precise statement that allows the court to work on sort of agreed, assumed facts. So, my lady, my lords, we say that although the precise nature of the rights that have been used has not been explained by the appellants, when my learned friend says that he accepts his clients have obtained a benefit, we say implicit in that must be the assumption that my client's permission, the need to, that is a part of the benefit that has been transferred, the value of that blocking right, as well as the right to be the first to resurrect Mr. Cushing on screen, as my clients pleaded. We say that the transfer of that benefit from my client to the appellant is what gives rise to a claim in unjust enrichment. And as we'll come to the law, and I'll show you that is not excluded by the analysis of Lord Reed in ITC or indeed any of the other authorities. So it's, and insofar as I'm not sure how much further I can go in terms of looking at the pleading, saying this is where the facts are. But this is a highly factually sensitive analysis, and the court is being asked to conduct it and resolve it against my client without the full facts being before it. And that's something that the court below considered was not appropriate, and in my submission they did not err in taking that approach. So with that, I think I'll leave the pleadings and move on to ITC, so the law, and my purpose here, my lady, my lords, is to show you that there is nothing within ITC that excludes the case that my clients advance. So tab 14 in the authorities bundle, and I'll try to take this relatively
Yes, please do.
quickly.
I mean, we're, I think, all well alive to the passages you would rely on, non-exhaustive, and all the rest of it. So just flag up the particular passages
I
you
will
say
indeed.
help you.
I will indeed. Starting with a general discussion, paragraph 37 under 3.8.1. The purpose, we say what Lord Reed was doing was not attempting to set out a definitive statement you get from 38. He's not attempting to arrive at a definitive
No,
statement.
I just said we've got
Okay,
those
you've
points.
got those. Then moving through, we rely also on, in paragraph 42, so having gone through those matters, and at the base 41, setting out the words at the expense of do not express a legal test and cannot be derived on exegesis of these words, as if they were the words of the statute. 42, we say that the reference to the structured approach provided by the four questions, that's Lord Staines's four questions, does not therefore dispense with the necessity for a careful legal analysis of individual cases. We rely on that as saying that individual cases, what's meant there is and must be meant, is the particular facts and the particular circumstance of those individual cases. It's acutely factually sensitive, so it is we rely on that as another point against or suggesting it's risky to decide unjust enrichment cases on a strikeout basis, in particular when they're not clearly excluded. At 46, we move to, so I'm only picking up the points that we particularly rely on. At 46, under the heading direct and indirect provision of a benefit, again, in 47, we rely on the terms such as in the final sentence, these are generally situations in which the difference from the direct provision of a benefit by the claimant to the defendant is more apparent than real. The use of the term generally, it's not always the case that they must be more apparent than real. This is a non-exclusive list, and indeed, having gone through the exceptions, the points at 48 and 49 that my learned friend has taken you through, so the examples of things that are more apparent than real, so agency, sham, assignment, coordinated transactions, and at 49, a different class again that is where it's meant to be more apparent than real. So this is a claimant discharging a debt owed by the defendant to a third party. When we get to 50, having gone through all of those, the general rule that's addressed there, so it's often been suggested there is a general rule possibly subject to exceptions that the claimant must have directly provided a benefit to the defendant. Lord Reed's characterisation of that rule as being helpful is subject, as he goes on, the situations discussed in the two preceding paragraphs can be reconciled with such a rule if it is understood as encompassing a number of situations which, for the purposes of the rule, the law treats as equivalent to a direct transfer, in the sense that there's no substantive or real difference. So understood, the suggested rule is helpful. But even there, so that's saying this is direct transaction are other things that the law treats as equivalent to a direct transfer, in the sense there's no substantial real difference. Even beyond those, we get the final paragraph. It may nevertheless require refinement to accommodate other apparent exceptions, and it would be unwise at this stage of the law's development to exclude the possibility of genuine exceptions or to rule out other possible approaches. So we say the fact that if we don't fall within any of the express points that are identified in ITC by Lord Reed, he's expressly not closing the door to us. We then see a number of points that are excluded under 52 and 50. So 52, we have incidental benefits. Again, that's not it's not suggested that what's before the court here now is excluded, so that's not expressly excluded. Economic reality, my learned friend relied on at 59. This is something that is excluded. What's addressed under 59 and 60 is to say that it's not merely a question of approaching something as a matter of economic or commercial reality, and that's plainly correct, but it's not to say that just because it's not logically, it doesn't logically follow that just because economic reality is not enough of itself to bring you within the scope of the unjust enrichment, it doesn't mean that it's wrong to have any regard at all to economic reality, so long as there is something about the economic reality that adds a further additional factor. And so in this case, my learned friend characterizes our argument as to do with the economic reality, but the mere fact we're praying economic reality in aid does not mean that our arguments are to be dismissed out of hand. The reason why we rely on economic, say that there's an economic reality and that a benefit has been transferred, is we say we had a right to primacy, we don't have it anymore, and the defendant has exercised it. So as in that sense, there is an asset that has gone from us and appeared with them, and that is not merely a question of them making a profit that reflects our loss. It is a thing that we previously had the benefit of, is ours no longer and has been transferred to them. There's one thing in the context of coordinated transactions. The key, well, the first case they refer to is the Banque Financière case. But
are you? How do you? So, the learned judge's judgment below said you'd focused on indirect benefit.
yes,
That's what I think he said in paragraph 41 of his judgment. That's presumably correct.
yes.
And is that your focus today?
It is, but it's an indirect in the sense that we have no direct contractual relationship. It must be indirect because we have no direct contractual relationship with the appellants. But we do not limit our, and so in that sense it's indirect. But the fact that something that has gone from us through the medium of permission, we say wrongfully having been given by, in breach of contract, having been given by the estate, to the appellants to do what they did, that is something that has transferred through the medium of the activity of the estate, the benefit that we previously had under our contract, the letter agreement. And so, now, Bernard says that can't be a coordinated series of transactions because of the distance between the two in time. And I think he's also on occasion said that they go in different directions because the contract between the estate and ourselves is the estate granting us certain rights. And then the estate again granted those rights to the appellants without seeking our permission first. But that's where we say you get the relevance of this, of the concept that's addressed in Goff and Jones and others, of interceptive subtraction in that what has happened is the estate has deprived us of the benefit of something that was ours by taking a step that was not contractually open to them lawfully in granting permission to the appellants. And so that's where I think the term interceptive subtraction, which is it has otherwise been used by in the context of trustees granting matters where they didn't have the right to do, it's analogous to what's going on here, but we are not saying that that the estate, as a matter of law, was not able, as the rights holder, to grant a license as they did. They were just contractually bound not to do so, and they deprived us of the value of something they previously granted us in so doing. So the nexus there is of the intervening party, the estate, who granted both sets of rights to people, is something that they have, in that sense, granted twice and wrongfully. And in granting it the second time to the appellants, they've deprived us of the benefit of it.
You don't go so far as to say, do you, that you were granted a right which amounts to some item of property,
No,
which has been wrongfully granted to someone else instead of you?
Well, we can't say it's because these are contractual permissions, and they're licenses and covenants and various. I can't say here is a thing that has been transferred in a physical sense.
And the
an item of
license was
property.
to use the image, performance rights, etc., for a specific purpose, making
Yes.
the TVM. You don't say that has in any way been acquired by the defendants,
Well,
because they made a totally different film.
My lord, we say they have acquired the right to use. They've acquired the right to resurrect Mr. Cushing for the purposes of their film, and we no longer. Our right was to do that for the purposes of our film, and was also to be the first person to do it.
Honing in on precisely what it is that
Yes.
gives you the right under your contract. It is, isn't it, the contractual right to refuse consent, either the right of veto?
That's the right. That's our right as against the appellant, and our right against anyone else. It's what turns our permission for the purposes of making the TVM into a right of primacy, in the sense of, so it's beyond it takes it from being a license just for the purpose of the film, but also to be the first person to resurrect Mr. Cushing. And so that's
It isn't limited to the first. I mean, I think, as Mr. Cullen said, you could refuse, even if someone else then did. If you gave permission once, you could refuse permission a second time, couldn't you?
yes. Well, we could until we make our own film. But what's been taken is, and what is of value, what we pleaded as a value, is to be the first doing it. So it's not to say that there isn't further value that's going on, but that asset of value, the right to control the first resurrection of Mr. Cushing, figuratively speaking, in a film, is something that has been taken from us. Now, and the question of again, it must be assumed that is something we say. We pleaded it as being a matter of value, of being the first, and I don't think it's certainly not disputed on this appeal that it is a particular factor of value. So. And how that is then, given what we're addressing here is at the expense of, so they have, we say, if you take it at that, analyse it in that way, the right to be the first to recreate Mr. Cushing in a film after his death, even if there are further rights to continue controlling anyone else doing it until we make our own TV movie, the right to be the first has undeniably, we say, been taken by the appellant. And in fact, when we say taken, it was granted to them by the estate in circumstances in which the state was not entitled, as a result of their contractual relation with us, to do that, though as a matter of the law of intellectual property rights, if the proprietor grants permission to do something, it's not open to my clients to go in and say, I want an injunction to stop it. Now, my learned friend said that if his clients had not sought permission from the estate and not been given it, which, as I understand, they did after they'd made the film, it was retrospective, 2016 is when they sought permission. If they'd not done that, then we wouldn't have a claim. My lord, I don't accept that entirely. We say that had that been the case, then the estate would have been suing the appellants, and we would have been parties alongside the estate, because we would say they have also been unjustly enriched in exactly the same way. But what we wouldn't be doing is suing the estate for breach of contract, as we did, and indeed the agent who procured that breach, against whom the claim is still live. So it's not, we were on the other side now in this claim from the estate because they gave permission in this way. Indeed, after we'd written to them and said, don't do it, we think this is what's going on.
So I think you were going to go to paras 61 and to 63 and onwards to deal with banque financière.
Yes, well, I was going to, but it's the coordinated transaction that is addressed in those paragraphs is are a particular kind of coordinated transaction where they are, it's true, closely connected in time. But that's not to say, what we say is none of those paragraphs exclude either as a further analysis of a form of coordinated transaction, or indeed any other approach under the law of unjust enrichment, a situation such as this. So all that I take from ITC on this point is it doesn't assist my learned friend, particularly to say we are not the same as the position in banque financière, because we don't claim to be the same. We just say that they're coordinated transactions in a different way, but a sufficient way to allow us to avail ourselves of the law of unjust enrichment.
What are the coordinated transactions here, then, you say?
So we say what provides the transactions in question are the two agreements that we're talking about. So the grant of permission by the estate in 2016 and the letter agreement and the film agreement from 1993.
It might be said that the 1993 agreement isn't a transaction in a relevant sense at all. That is what gives you any right in the first place. Your complaint is that what was given to you by that agreement was later transferred pursuant to a transaction to the defendants.
Well, my lord, that is another. That is if one analyses this in a form instead of saying, well, it's a form of, I think the term used is interceptive subtraction. So they granted the appellants granted something that they weren't entitled to do. Then that's one way that accords with your lordship's analysis in that sense. But if we're trying to analyse this, and I'm keeping my cases as broad as I can because I'm trying to avoid being struck out, we say, well, these are. If it must be a coordinated transaction, then what coordinates these two is the fact that the very subject matter of them is the same, and the coordinating factor, I think, is the activity of the estate. So it's coordinated not in a prospective or a retrospective sense. It's coordinated in the sense of who is the entity. What's the entity that is engaging in this. I mean, there's a limited utility in the attempt to go through ITC and say, look, this, I fall within this limb or another, because I can concede that there is nothing set out within ITC that says, in terms, my case is available to me as a matter of unjust enrichment.
No, we've got your point. You say it doesn't expressly exclude it.
My lady, yes, sorry, I don't.
No, that's fine, don't worry. But just go back to your answers to my Lord's helpful questions. So, as I understand it, you say subject matter, and you've seen what Mr. Cullen has to say about that. That can't be the coordinating factor, because by definition you're dealing with a situation with transfers of value. I mean, it's very nearly always going to be the same subject matter. But you say it's also the activity of the estate. So the fact that what the estate entered into the 93 agreement and then entered into the 2016 agreement. So is it the identity of the actor that is the coordinating factor, or what? And
although it's not merely the fact that the subject matter is the same, it's what can be done in respect. So these are the subject matter of the rights in respect of which license has been given. So the broad sense of the right to reproduce, Mr. Cushing. That's the same, but the manner in which that right is to be exploited, and in particular, the fact that it's the primacy of it. We say that is something that brings it. It's a specific and different qualification of the nature of the right granted in respect of that asset, the intellectual property right.
Sorry,
Again,
I didn't understand that a right of primacy was granted in the 2016 agreement.
By giving permission without obtaining our permission first, the 2016 agreement usurps our right of primacy.
I understand that, but it didn't confer a right of primacy, did it?
It confers the right to do the thing first, because it confers the right to do the thing. No one's done it before. We have the right to control the right of primacy. I'm not sure.
Well, on the face of the 2016 agreement, there was no element of primacy in it. The right was to use the Peter Cushing images and so on and so forth for the purpose of a specific film.
My lady, yes.
It didn't prevent anybody else using the same imagery or aspects by somebody else for a different purpose. It only conferred those limited rights.
My lady, no, it didn't. But what it did by granting, by the effect, the value of what was passed, included the value and the effect of primacy. No one else had done it before. My clients had the right to be the first to do it. The estate grant permission to the appellants to do it. That happens to be first. It doesn't say on the face of it, you now can do this first, but the effect of it is they could do it first, and the effect of it is that I don't get to control who does it first, and I don't get to do it first myself.
This probably isn't relevant, but there's no suggestion that when you found out about the prospective 2016 film, you said, hang on, wait, we want to make our film first.
No, there's no evidence of that. No.
The film's not going to be made, is it? I mean, that's the reality. The TVM.
My lord, I don't concede that. I don't concede that. Though it's... My lord, it was all a long time ago. One can read into it, what one does. So, there's only, my lords, my lady, there's only so far one can go by way of analogy in cases such as this. But I would say that the facts of the BFC case are to a degree instructive in this, in that what took place there and what it concerned in terms of subrogation of a right was the entity that was enriched had their their charge promoted. They moved up. In terms of a form of the succession of creditors as a result of what Park had done. But there was no contractual relationship between BFC and the party that benefited. There were two separate contracts. There was a contract between BFC and Park, by which £30 million was advanced. And as a term of that contract, an important term of that contract, it was agreed that the other group companies of Park, including the one that eventually benefited OOL, would not demand repayment of any debts they were owed until BFC had been repaid. Now, what then happened is you have a separate contract between the party that was enriched, OOL, the group company, who had their charge over the property, so that they had a contractual basis that they then have that charge. And at that point, they received a benefit as a result of the breach of the contract between Park and BFC. If one puts it at that level of generality, then we stray into my learned friend's analysis of saying, well, you can't just say that unjust enrichment arises because you have a contractual right that's breached and someone else, a third party, has benefited from it. That's it. One needs to look further into the subject matter of it. And in BFC, the subject matter was held to be a coordinated series of transactions because of proximity in time and because of the reasons why a third party was paid and so on and so forth. Here we say there's a different reason why there's enough nexus, sufficient nexus in the words of Lord Reed, which is this commonality of the subject matter and the same party granting, in breach of an earlier contractual arrangement, a right that should have been my client's to the appellants. So that's our case, and we accept that it is it's not franked by anything within ITC, but we do say that it is something that is not it's not alien to the scope of unjust enrichment, as one can see when we look at the extracts from Goff and Jones that address interceptive subtraction. So if I may, I'll take your lordship to that. And then I'll draw matters together and conclude.
Thank you very much indeed. Yes.
The relevant parts, I just want to put this in context. The section, it's behind tab 22.
Yes.
Is a section entitled Interceptive Subtractions. And what's said at 6.124, I don't know if the court have had an opportunity to read this at all, or whether I shall take you through it, but I'm happy to do so. So the English court, if I can ask you to read 124 down to the end of 6.126, perhaps.
So what category of case, what sort of case is this, do you say?
So we say, first of all, as a matter of fairness, what I'm doing is pointing out that this concept of interceptive
It's highly controversial.
is highly controversial, but and is thought to be limited, in particular, limited to where X had a pre-existing legal liability to C. Okay, so this is, and just to get this in, this is English courts have sometimes afforded C a restitution remedy against D in respect of a benefit which D immediately obtained from X. So in this, as we look at that, X would be, to orientate ourselves, X would be the estate, C is my client, and D is the appellants. So there we see, so it's a controversial doctrine, but even on its limited form, we say here there is a pre-existing legal liability owed by the estate to my clients, and it is that pre-existing legal liability that has been usurped in the granting of the rights that we complain of as a benefit being transferred from us to the appellants. So we then see at 6135, having gone through, so there are 6127 to 6134, there are a range of possible matters where this has been held to potentially be available. And then at 6135, if some exceptional instances of so-called interceptive subtraction might demonstrate a sufficient connection to support a restitutionary claim, where should these cases be located within the landscape of the law of unjust enrichment? In the past, some legal scholars have tolerated these cases as a modest extension or exception to a general direct enrichment requirement. So that would be a part of it's a further exception to the requirement of direct enrichment under ITC. The benefit immediately received by D from X is obtained at C's expense, insofar as C's own rights against X are correspondingly diminished. We say, again, in this case, our rights of primacy have been correspondingly diminished by the grant to the appellants by the estate. And there's a reference, as in investment trust companies, Lord Reed did not mention these cases in his exposition of cases equivalent to the direct provision of a benefit by C on D, and some will say they cannot be regarded as equivalent. Just pausing there, again, it wasn't an exhaustive list, and so it doesn't close it down. But what we then see, reading on, however, as we explained earlier in this chapter, Lord Reed's concept of direct enrichment is not necessarily as narrow as this assumes. Some examples that he gives are situations where C played no active part in the conferral of benefit on D. Another challenging question concerns the relevant ground for restitution. The most obvious candidate is the ground that Chapter 8 identifies as lack of consent. The reason for restitution lies in C's lack of consent for the transaction between X and D, by which D was enriched at C's expense. So, again, although the ground of unjustness, as it were, is not before you here, there is a strong, I say, parallel between this analysis and what we are seeking to address here. And then it goes on to say, the explanation looks more difficult, however, if the relevant subtraction from C in a particular case depends on an election by C to treat his rights against X's discharge and to that extent upon C's consent. Well, not here, we've not elected anything. So that refers forward to Chapter 8, the section lack of consent and want of authority, which is a passage I particularly referred to in the courts below, or a chapter I referred to, and which was considered by those courts. So I just want to flag up how that works and which, so when we then go finally to the judgment below, I can show you that this, we're not, just give you the context of where these things were argued. So behind tab 24, under the heading lack of consent and want of authority, we have Chapter 8. This is 801 is what my learned friend showed you to in his submissions on at page 648. So again, this is the summary of cases that are not addresses at the base of this paragraph, 81 before we get to 802, a different category of cases exemplified by misapplications of trust assets by trustees and misapplications of corporate assets by directors, where X owns or controls assets subject to duties and powers to deal with the assets for the benefit of others. where D is enriched as a result of X's unauthorized dealings with the assets. Now, those are fiduciary relationships. There is no fiduciary relationship here, but there is a contractual relationship. So that's what we're relying on as we say that might come in. But this is only the introduction. What I really wanted this in for is, this is only the partial copy. Sorry, if you turn forward to,
Can I just interrupt rudely? I think the lights are not working. Could somebody please just switch all the lights on in here? It's terribly dark. Can you see anything down there?
we can,
It really is quite dark.
might
and
just
I
be an effect of
realise
my
why.
submissions.
Apologies for interrupting, but thank you. Yes.
Malay, perhaps you could turn to tab 28, which is the entire, the fuller section of Chapter 8. So lack of consent of wanted authority. What I just want to show you is give you the context of the passage from Goff and Jones that I'm going to be taking you to.
Thank
So that's much better. Thank you.
Ms. May.
So 801 we've just looked at. I believe that 804 sets out what the structure of the chapter is. It says this chapter is organised as follows. And it refers to Part 2, which considers a number of obstacles in various ways hamper the recognition of lack of consent or want of authority grounds for restitution. Part 3 considers two-party cases where D is immediately enriched at C's expense. Parts 4 and 5 then examine three-party cases where D is immediately enriched as a result of the actions of X, but more remotely enriched by C. The primary concern and the subject matter of Part 4 is whether C has a claim against D on the basis of either C's lack of consent or X's want of authority. And then it goes on to say Part 5 is when you... So we're looking at Part 4, which is behind the next tab. So Section 4, three-party cases, claims by C, personal claims at common law for value received. That's not, and where I'd like to pick this up is, I think, at 8105, it sets the context of what's going to be addressed in the part. But at 8114, we reach something that we rely on as being a class of cases. And this is all in the context of a want of consent, but the cases that are being discussed are three-party cases in which a benefit is going from a third party X to the defendant rather than going directly from the claimant. So 8114. There are other cases where D appears to have been more remotely enriched at C's expense without C's consent, but without receiving any asset which belonged to C or any traceable substitute for C's asset. So again here, we can see that there is no asset that has gone in terms of a physical form or gone from us to the appellants. In these cases, any personal claim C might have to recover the value of D's benefit obviously cannot be explained as vindicating any title which C might retain or be afforded to any asset which D receives or retains. However, it can be explained as a claim in unjust enrichment based on either C's lack of consent or X's want of authority. And then at 815, we start off with a line of authority of D usurping an office to which C was entitled and receiving sums that instead C would have been entitled to. But of particular relevance, although nothing was decided on the point, but it does feed into the realm of intellectual property, is at 8117. And again, this is all analysed in the context of interceptive subtraction. This is the reference to BSI and Blue Mountain Music. And so reading that, similar issues could have arisen in BSI and Blue Mountain Music. There, the question arose whether C, the owner and exclusive licensee of song copyrights, could bring a personal claim in unjust enrichment against D, who had allegedly wrongly received sums as royalties from X, collecting societies, on account of the works. In the event the point did not rise for decision, it turned out that the claimant didn't own and was not an exclusive licensee on the facts of the rights in question. The judge therefore refrained from deciding whether the claim would be available if the contrary conclusion had been reached, but he did suggest that the claim would be right at the fringes of the developing part of the law. He was right to say then, in that this was a case involving a form of interceptive subtraction, and it was questionable whether D could be said to have been enriched at C's expense if the collecting society's liabilities to the copyright owners had not been discharged. So here the authors are saying it's right to say it's right at the edge, and I think it's right at the edge as our case might be viewed. But the reason why they cavil with this is not the concept of the collecting society providing royalties to the wrong parties. It's because it was questionable whether the at C's expense requirement could have been satisfied if the collecting society's liabilities to the copyright owners had not been discharged. So there was no, it wasn't at the claimant's expense because they could still collect their money from the copyright holder. So that was the problem that arose there, certainly according to these, the authors of this. That's not a problem that we face here, is all I would say. I'm not saying that there might not be other problems that come up at trial, but that's not a problem that we face here, in that our right, as we characterize it, our right to primacy has been extinguished. So in granting permission to the appellants to make Rogue One and put Moff Tarkin within it, my client's right to be the first to do so and to control the first use of that has been extinguished. And so we say that conceptual hurdle that these people have identified is not there. So, my lords, I've trespassed on your time, but in summary, we submit that at the very least it's arguable that on the peculiar circumstances of the present case, the benefit obtained by the appellant in obtaining the right to use the intellectual property rights and other rights of the estate to resurrect Peter Cushing was at the expense of my client's right to resurrect Mr. Cushing, and indeed to be the first and to control the person who was the first to do that. And if we're right on any one of those characterizations of the detriment to us, then the at the expense of point under this appeal cannot be answered against my client, we say. So I think it's probably worth, before addressing briefly the further arguments, my friend's floodgate arguments insofar as necessary, it's probably worth looking at how the judge dealt with this, because I'm not sure we've actually looked at the decision of Mr. Mitcheson, case he's sitting as a deputy. But in my submission, there is no error in his approach, and unless the appellants establish that he was clearly wrong in law, because my case is simply not open to me and can be decided firmly against me, then there's no basis for disturbing the decision below. And in my submission, his approach was perfectly sensible. Behind tab 5.
The analysis starts at para 47.
It does.
Common sense he relies on. Principally agrees with the reasons given by the master. In a field of law which is not yet settled, he can't be certain that the claim would fail. Agrees that transactions in ITC are much more connected, but he says direct or indirect dealings, although indirect were the focus. Accepts your argument essentially that whilst there's no case supporting you on the facts, equally there's nothing excluding you, which is the argument you've maintained here.
My lady, yes.
And then concluding, para 53, just can't say unarguably fail.
and then at 54,
Yep.
56, absolutely correctly saying three-party cases, recording the Master's correct observation, three-party cases or indirect benefits are some of the most difficult and fact-sensitive, and then saying that he's fortified by our reference to the importance of not deciding matters in developing areas of law on assumed facts.
And endorsing the Master when she said, this is the one at the edges of the scope of unjust enrichment, but not entirely fanciful.
Absolutely, and my lady, to be fair, that neither the Master nor Mr. Mitcheson has said that they consider that my client's case is clear or particularly strong, but what they're not doing is striking it out. We say, we strongly urge you to take the same approach. The two further arguments that are relied on by my learned friend, there's the floodgates point. Even without considering the effect of a statutory exclusion from the availability of, implied exclusion from the availability of unjust enrichment, if there's a regime addressing licensing, in my submission, it's wrong in principle to be concerned about floodgates opening at this stage. This is a strikeout. And it's, if the Court of Appeal does not strike out, grant the appeal and does not strike out my case, this will have to go to trial and it will be decided in the round at trial with all the defences that my learned friend has got lined up against me. And if it turns out that I prevail at trial, this is a very peculiar set of facts. And in my submission, it cannot be said, looking at it now, that this will crack open the floodgates and lead to a zombie army of film stars being resurrected in any sense. It's just not sensible. And the reference to SKP and Apotex it's a different area of law. It just has no application in the present facts, we say. So, unless I can assist you further, we urge you to dismiss
You've been very helpful and, like Mr. Cullen, very patient with us. I forgot to ask whether Mr. Hill wanted to follow, but Mr. Marshall, I'll remedy that in a moment. Would you like to follow?
I'm grateful, my lady, I don't.
Good. All right then. Yes. Mr. Cullen.
My lady, my lords, a few points. First of all, to pick up something that's been said at the beginning and end, and this is the absence of authority point. There is no authority supporting my learned friend's position. He's wrong to say there's no authority supporting my position. I rely on the Supreme Court authority in ITC. If my learned friend's point is that I can't produce a case which is factually similar to the case he is advancing, well, with the utmost fondness, I say perhaps that's because no one's ever been as wrong-headed as my learned friend has to advance.
That's a 3:15 p.m. submission, Mr. Cullen. Yes.
But, my lady, it's striking that there aren't cases where anyone's advanced an argument of this kind on similar facts. And we say that in itself is telling. Now, then my learned friend made submissions to the effect that there are factual obscurities which the court might need to have regard to in order to make a decision on the narrow point that's before the court. I'm not sure that I really got what those were, except possibly the point of construction of the 1993 licence, which I will come to. Now, so far, and there is another point about what is it that my clients did. I'll come to that as well. Now, to deal with the point of construction of the 1993 agreements, first of all, I was very surprised to my learned friend say that this is the first time it's raised by me this morning. First of all, the points I made to the court this morning about what the agreements mean seem to me to be so blindingly obvious that my learned friend can't possibly have been surprised by it. Secondly, I made identical submissions in the court below. And in any event, our skeleton makes the position clear if you take the core bundle and look, for example,
Give us the reference, 'cause I think
paragraph 16, first of all.
No, that's fine. Paragraph 16.
Paragraph 16, where we say, we refer to this right, this claimed right to resurrect, and we say it's apprehended this is an attempt to imbue it with some sort of proprietary quality. It's clear that it's nothing of the kind. It left the estate free to grant, to have granted the relevant rights at any time prior to TVM being produced, and more importantly, it does not give any positive right at all. It's a purely restrictive covenant, and we make the same point in paragraph 37.3, where we say the letter agreement does not confer any such right, that's to say a right to first resurrect, and see either it gives the benefit of a covenant that they will not grant permission, etc., etc. So this can't have come as any surprise to my learned friend at all. The construction that's now sought to be put upon the agreement, we say, is hopeless. It's and for reasons I'll come to, it doesn't matter anyway, to the analysis. But it's hopeless for this reason. The idea seems to be that the claimant could go on to make a film resurrecting Mr. Cushing, even if he rendered no performances for the programme at all. And that's said to arise by virtue of paragraph E of the letter agreement at page 35 of the bundle. We say that's plainly not the case, because the rights granted under paragraph E are only rights to supplement, complement, facilitate, or complete, to exploit Mr. Cushing's performance in the TV movie. So the rights under E only arise if and when there has been performance in the TV movie. And that can hardly be surprising if one goes back to, for example, the payment provisions in the main agreement behind tab 2, where one sees them at clause 4, subject to the provisions, etc., etc., consideration for all services rendered. It's all tied to the guaranteed period. It's all to be paid 25% within 7 days from the first day of the guaranteed period and following.
But the clause H is not so limited. It refers only to the processes and techniques referred to in E.
No, but the point I'm developing is that by virtue of the agreement, I'll come to finish the bridging, the provisions in effect mean that Mr. Cushing is not being, it doesn't get paid anything unless and until the guaranteed period commences and he starts rendering performances.
What does it? Surely the word facilitate in clause E mean that you can use doubles to facilitate his performance. And if you can do that, why does he need to do anything from his, as it were, sickbed?
Well, we say that's clear from the wording of E. It's facilitating his performances. It assumes there are performances in the TV movie that these techniques will then be used to facilitate. What there cannot be is that this is a freestanding right to use these techniques in circumstances where Mr. Cushing never actually rendered any performances. And we say that makes obvious sense in the light of the fact that Mr. Cushing doesn't get any payment unless and until the guaranteed period arises under clause 4. The guaranteed period is defined under clause 3, being effectively the period during which he's going to provide performances. So, if my learned friend's position was right, and this is in a world where we know, in fact, the guaranteed period never did arise, and to make that good, that appears from the claimant's reply to our defence to counterclaim at paragraph 4. The guaranteed period was postponed and never in fact commenced. And Mr. Cushing died before rendering any performances. So in my learned friend's case, little e was intended to give a right to make the film using the techniques in circumstances where Mr. Cushing wouldn't be paid a penny for it, and in circumstances where Mr. Cushing wouldn't have rendered any performances which were capable of being supplemented, complemented, facilitated, or exploited.
So this is all about the clause 4 link, i.e. the payment link.
My lady, yes. So the parties cannot conceivably have intended that there would be some right to make a film without Mr. Cushing actually rendering performances, but solely using E after his death. The whole point of E was to facilitate, and those other verbs, actual performances that had been rendered. But it never got to that stage. So the idea that E contained or created some continuing right to use those techniques even where the performances weren't rendered, we say is completely false. And then one comes to H, and here what my learned friend seeks to do is basically, well, it's rewrite it with wire, which either, as Lord Justice Zacaroli pointed out, doesn't really make any difference to the meaning at all, on one view. On another view, it completely changes the meaning in the sense that what's provided there is an apparently limitless, as to time, right to prevent or to block the use of resurrection rights, if you like. Whereas what we're now told is that actually this right under H somehow expires at the time when the film is produced. One doesn't get that from the words at all. So this new way of putting the case, we say doesn't stand scrutiny when set against the wording of the agreement. But we say in any event it makes no difference to the analysis, because what one is still left with is that what is sought to be enforced here against my client, and what is said to have been breached, is a bare contractual restrictive covenant under H. My learned friend uses this idea that there was a continuing right to make the film, make the program, as giving rise to some sort of broad economic benefit argument. But that's inconsistent with the agreement. It's completely unreal, because obviously the claimant's never going to make this film, and never would have made this film without Mr. Cushing's performances. But in any event, as Lord Reed says, such appeals are illegitimate. One has to look at what actually is going on here, and the right that has been infringed, if any right, is the Clause H right, and it is a bare restrictive covenant. One can go further, and this comes back to a discussion I had with the Chancellor this morning, is that if my learned friend's new construction is right, then what it does appear to amount to is an exclusive license of performers' rights. Because what is being said is the claimant had these ongoing rights under E to use various things, but including performances from past films. And by virtue of H, that right is exclusive. Now, if that's correct, as I said earlier this morning, that in fact, and bizarrely, and one of the reasons why it shows the case to be wrong-headed, that the effect of being an exclusive licensee would put the claimant in a worse position, because he couldn't then show that anything in the exclusive license had been transferred, obviously, because he remains the exclusive licensee. All he would have would be his rights under the exclusive license to sue the estate, and possibly, as exclusive licensee of performers' property rights, rights under the statute, under section 191L, the rights of an exclusive licensee to enforce property rights.
But he says he lost the primacy. What about that point?
Well,
Being first.
That's not in the agreement at all. That's just his colouring of the agreement to create an economic benefits argument. He wasn't given the right to be first. One doesn't find that anywhere in the agreement. Nor was my client given the right to be first. One doesn't find that anywhere in the agreement. And certainly there was no right to be first transferred, as I'll come to. But just to finish this point about performers' property rights, it's my learned friend's own submission that he makes that when one is in the territory of statutory rights of that kind, then unjust enrichment claims are ousted. So even if this argument is right, then on his own case, he cannot succeed with an unjust enrichment claim. His remedies should be those of an exclusive licensee of performers' property rights. Moving on, my learned friend took you to the 2016 licence, and he accepted that the rights there weren't coterminous with the rights that he relies upon. In fact,
But included them, he said.
well, it doesn't even include. They're dealing with completely different things. My learned friend's rights are dealing with the right to use certain things within his film. These rights are dealing with my client's rights to use the likeness, including images from previous films made by the earlier films made by my client, within that film. They are just dealing with two completely different things. Now, my learned friend, in this context, developed his point about, well, we don't know what it is that the Fourth and Fifth Defendants have done in relation to the image rights that were exploited. But that, with respect, is completely irrelevant. What my client has or hasn't done doesn't matter. As my lady pointed out, what matters is what's in the agreements. My learned friend's case is that the 2016 agreement transferred something of value from his client to my client. To assess that, one needs only to look at the terms of the agreement. And we say when one looks at the terms of the agreement, it is perfectly plain that there is no transfer going on at all. What is happening is a grant is contained in the 1993 letter agreement, even assuming that my learned friend's construction of that agreement is correct. That is one thing. There is then a separate grant to my client 23 years later, of a different right to do a different thing, and the idea that that the second one transfers something of value by reference to the earlier one, we say is simply unsustainable on any view. The further idea that they should be regarded somehow as coordinated is just cloud cuckoo land. We submit that there is simply no way in which one could regard there being a transfer of value by reference to these agreements. And now my learned friend talked broadly in terms of, well, what's happened is they've been deprived of a right to which they were entitled, deprived of something of value. Well, that may or may not be the case, but that is not, and is a quite different thing from being a transfer of value from the claimant to the Fourth and Fifth Defendant. All that says, at most, is that the executors have done something to cause the claimant's loss, for which the claimants have their rights against the executors. But it does not mean to assert that there has been a deprivation of something of value, that it must necessarily have been transferred to us. It simply isn't a connection there.
I mean, on coordination, Mr. Moody Stewart relied on the nature of the subject matter and the involvement of the activity of the estate.
Yes, well, my lady, so far as that is concerned, that is so far from what Lord Reed contemplated by coordinated transactions as to not be in the same universe. One needs only to look at Lord Reed's discussion of the Banque Financière case and Meneleu to see what he had in mind in relation to coordinated transactions. In a sense, as I submitted earlier, it's implicit in the language he uses of coordination. it's not simply about commonality of subject matter. Otherwise, the net would be cast far more widely. It's about, in effect, being able to collapse transactions into one. You have separate transactions along a chain, but the law can see through those and effectively regard them as one transaction.
There's almost got to be, you would say, a sort of causative link or some sort of common purpose or common, causality.
Yes, it's put in case there must be an intention that runs through, that they should all take place, as it were, so that when one starts the ball rolling, you know where it's going to end up. And on that basis, one can reasonably regard them as being one transaction. And one sees that from the cases Lord Reid refers to, such as Relfo and Banque Financière being one. And my learned friend seemed to suggest that that might provide him with some support for his idea that someone who suffers loss as a result of a breach of contract can claim restitution against a third party. It doesn't provide anything of the kind. Banque Financière is a slightly complicated factual case, but it was essentially a completely orthodox application of the principle that if you pay off a secured creditor, you can stand in the secured creditor's shoes by way of subrogation. Amongst the complicating factors were that the payment off had to go via a third party to avoid Swiss banking regulations. But it was that feature which made it an indirect transfer, and it was that feature which the court had, as it were, to collapse and see through, and it was prepared to do so.
I mean, with some trepidation, going back into this question of coordinated transactions, all the cases, the examples that Lord Reid gives, are really cases where there is one transaction whereby value leaves the claimant, another transaction whereby value arrives at the defendant, and there's something else going on in the middle. Yeah. You either collapse it as a sham, treat it as agents, etc. We're just not in that territory. The first transaction here, the 1993 transaction, is not any part of transfer of value. It's the creation of what is said to be value in the first place. We have here only one transaction that's said to transfer value. That's the 2016 agreement, isn't it?
Yes, but this probably gets to the heart of it, because there's not a transfer of value from the claimant at all, because it is a transaction entirely entered into by the executors with my client, granting rights to my client.
Unless that transaction involved the transfer of some item of property, which in fact had been already transferred by another transaction to the claimant.
Yes, but then one gets into consideration that if it's a trust situation, then you can trace it, or if it's an agency situation, there are various things that might follow from that. Yeah. But this is really at the heart of it, if I may say so. I mean, yes, any analysis based on connected transactions, frankly, looks a bit daft because of the distance in time. My learned friend is forced to do that because that's the only way he can get his case off the ground. But the fundamental problem is, and why connected transactions won't get him home, and he needs that because for all a fortiori, he can't show direct transfer, is the point is the 2016 license does not transfer any value from the claimant to my client. It has nothing to do with the claimant, beyond the fact that it might have infringed the claimant's rights, in which case the claimant has its conventional remedies. But it simply cannot be regarded as a transfer of value from the claimant to my client. One then gets into I've forgotten the jargon now.
I've got it. I'm now an expert.
Interceptive subtraction.
Interceptive subtraction.
Yes. Now, these aren't going to help, hopefully. These aren't going to help my learned friend either, because, as I said earlier, for this kite to fly, he has to be able to show that the license that was granted to my client should have been granted to him. And it's simply impossible for him even to begin to suggest that. Because the license that was granted to my client was for a different film over a different subject matter, and there's no sense in which it could be said that it should have gone to him. And indeed, one might add, that proposition is made to look even more absurd by my learned friend's new construction point, because on that basis, he didn't need a license, he had one already. And so the idea that the license granted to my client should have gone to him and somehow got interrupted, it becomes even more unsustainable.
But he goes back to this point, he's lost the primacy. That's what he lost.
Well,
and that's what should have gone to him.
Then that may...
That your client got primacy, and that was, well, not should have been granted to him, he already had it.
But that's not a transfer, there's no transfer of that from him to me. That, all he's describing is he's describing a commercial effect of what's happening.
Yeah, I understand.
And the result of that might mean that his claim for damages against the estate is bigger. It might mean that if he doesn't have one, but if he had an OBG and Allen type claim against my client, but he hasn't got such a claim, because he doesn't feel able, quite rightly, to assert that we had the necessary knowledge and intent. My lady, all that goes to, if it goes anywhere, is the quantum of my learned friend's damages claim against you. It is simply pie in the sky to say that what happened here was that the estate transferred some right to do something first. That's not the reality of what was going on. And then just finally, to pick up the point about the BSA Enterprises case from the authorities, this is the one about the payments through the Performing Rights Society having gone to the wrong party. Which is behind tab 29. This is we're in interceptor subtractions territory effectively, and behind tab 29 at paragraph 155, various examples are given, and they're all interceptor subtraction type cases, i.e. where the claimant is entitled to a sum of money.
Sorry, I've not got the reference.
I'm sorry.
Tab 29, 8.
Tab 29, it's para 8115 on
Thank you,
page
thank you. Yes, I have it.
662.
Yes, got it, thank you.
They're all examples of, as it were, usurpation of office, where the claimant is entitled to a sum of money and the defendant receives it wrongly, and therefore the defendant has been unjustly enriched. It's at the claimant's expense, because on this hypothesis it must be the case that the claimant is no longer able to recover from the payee because the payor has been discharged. And so that, one can see, gives the right to recovery. And my learned friend then turned over to paragraph 8117 and pointed out that the BSI Enterprises case was left undecided but at the margins. It didn't need to be decided because of the judge's factual findings elsewhere. But what that shows is that was a case where the claimant's case was that a performing society had been paying the wrong person all along. And why the editors of Goff and Jones cavil as to whether this claim could have succeeded is because they say, well, actually, the Performing Rights Society, in making the payments to the wrong person, wouldn't have been discharged. So it's not at the claimant's expense, because the claimant can still just go to the collecting society and claim its money. But if the position was different, and in fact the payments from the collecting society had discharged, if the collecting society's obligation to make payments had been discharged by the receipt of the wrongful recipient, then it would have been potentially within the usurpation of office analysis. But none of this has anything to do with our case, because all these scenarios assume that the third party is obliged to pay the claimant and pays the defendant instead. So the defendant is getting something that should have gone to the claimant. But in our case, for the reasons I've said, it cannot sensibly at all be suggested that the license agreement which my clients entered into with the executors should have been entered into, should have gone to the claimants. It's simply unsustainable. Unless I can assist the court further.
Any more questions? Any more questions? Well, thank you very much indeed, Mr. Cullen. Mr. Hill, your moment has come. Do you follow?
No, I do not.
All right, thank you very much. Anything at all? No. Well, thank you both very much, all four counsel and those sitting behind them, who I'm sure have worked very hard to ensuring the smooth progress of today's hearing. We obviously are going to reserve our judgments. We will, as ever, aim to produce a draft to be distributed under embargo in the normal way as soon as possible. We are conscious of the delay in this matter, but equally conscious of the need to produce a helpful judgment. And it's a busy time of year coming up towards the end of term. So I'm afraid, without having consulted my lords, my best guess is that we are looking at 2026. If that changes, then you'll be delighted. If that is the case, you will not be surprised. If there are any significant delays of which we feel we should inform you, we'll keep you informed. Are there any particular dates or events that you need to tell us about in order to take into account?
My lady, no, not from our side.
No.
I'm somewhat busy in March, but I'm hoping it may be before.
Yes. Oh, well, that's encouraged. Okay. Yes, we will keep in touch. As I say, we are aware of the delay so far. Well, again, thank you to those assisting the court, below the court clerk, court ushers, everybody in court. Thank you very much indeed. That concludes the hearing. Thank you.